Good morning, everyone, and welcome to another of our quarterly pensions webinars, our final webinar for 2023. I'm Richard Evans. I'm a partner in Mayer Brand's Pensions Group, and with me today are two other senior lawyers, Henry Corrigan, also from the Pensions Group, and Ben Ward, who's an insolvency and restructuring specialist with substantial pensions experience. Our theme for today is insolvency and restructuring and implications for defined benefit pension schemes. We'll start by looking at a worst case scenario, an insolvency which brings down the employer and with it the pension scheme. We'll then consider whether restructuring might deliver a better outcome. Finally, we'll look at some practical points, contingency planning, so that trustees can move quickly if faced with an insolvency or restructuring. There should be time at the end for questions, so if you have any, please submit them via the chat function. I said we'd start with a worst case scenario, so let's take a simple example. Blueco sponsors a scheme with a substantial buyout deficit. After a long period of trading difficulties, Blueco's creditors put the company into administration. Administration is a triggering event under the employer debt legislation, Section 75, and also under the PPF assessment legislation. Most other insolvency processes would likewise be triggering events, as shown there in the box on the slide. The net result is that Blueco becomes subject to a Section 75 debt, and the scheme enters PPF assessment. Members are likely to end up with PPF compensation, or perhaps a buyout which secures more than PPF compensation, but less than full benefits. Let's look in more detail at the Section 75 position. A debt is triggered at the start of the administration process. Now, technically, that debt is contingent. In other words, it becomes payable only if the scheme falls into the PPF or is wound up. In practice, that's only really significant if a scheme rescue enables the scheme to continue, in which case the debt disappears. We'll come back to that point later. The debt will be equal to the buyout deficit at the start of the administration. It may not be formally determined until much later, but even so, it will be based on the position when administration started. That means that buyout costs are assessed using historic pricing rather than current market rates. The trustees or the PPF on their behalf will be able to claim for the Section 75 debt in the administration. But remember, the statutory position is that trustees are unsecured creditors, so they're likely to recover only a fraction of the amount owed. Of course, the trustees will be in a better position if they have in place security over the employer's assets or rights against the parent company. And in some cases, the pensions regulator might be able to pursue a parent company or other connected parties using its moral hazard powers. Sadly, none of that applies in Blueco's case. As the Blueco scheme is a single employer arrangement, administration triggers PPF assessment. Assessment is a substantial process, the purpose being to determine the ultimate fate of the scheme. And there are three possible outcomes. In some circumstances, the scheme may be able to continue via a scheme rescue. In the absence of a rescue, there are two alternative outcomes depending on the scheme's funding position. The first is that the scheme falls into the PPF, which we'll call PPF entry, or alternatively, the scheme may emerge from assessment, but will then have to be wound up, and we'll refer to that as PPF plus. As I say, assessment is a substantial process which may take months or even years, and during assessment, special rules apply. One immediate consequence is that benefits paid cannot exceed the relevant compensation levels. This will mean adjusting some benefits already in payment and adjusting paid on some subsequent retirements. In addition, the special rules tie the hands of trustees in various ways, as mentioned on the slide, while giving powers to the PPF. In particular, the PPF steps into the trustee's shoes when it comes to recovering any Section 75 debt from the employer. Now let's look in more detail at the three possible outcomes which I mentioned. First of all, the least likely, which is scheme rescue. This applies if either the employer survives as a going concern and continues to sponsor the scheme, or if some other entity steps in as scheme sponsor. Where there is a scheme rescue, the scheme exits PPF assessment and remains ongoing. In this situation, the Section 75 debt triggered on the insolvency falls away. PPF entry applies if there is no rescue and the scheme is underfunded on the PPF basis. In other words, if the trustees wouldn't be able to secure benefits over and above the level of PPF compensation. Where PPF entry applies, the scheme falls into the PPF and members receive compensation in lieu of benefits. Remember that compensation doesn't cover full benefits, at least not for members below normal pension age at the start of the assessment process. Such members are covered only for 90%. PPF Plus applies if there is no rescue, but funding is over and above the PPF basis. Here the scheme exits assessment, but must then be wound up. The trustees use the assets which they have to buy out benefits, scale down as necessary to the extent that there is underfunding. So, returning to Bluecow's case, there was no scheme rescue and only a small recovery under Section 75. The funding level meant that it turned out to be a PPF case. The scheme emerged from assessment and was wound up. Benefits were secured via buyout, but there was a haircut, especially for members below normal pension age at the start of assessment. Bluecow itself was wound up. Now that's a disappointing outcome, but sometimes it may be unavoidable or indeed appropriate. There was an interesting case about this recently, Bywater. In that case, there was a DB scheme with a distressed employer. There were substantial unpaid contributions, and the funding position was only getting worse because benefits were still accruing. Furthermore, the employer wasn't sharing relevant covenant information with the trustees. The trustees concluded that they should wind up the employer based on the unpaid contributions and thereby terminate the scheme. It was expected that the scheme would end up falling into the PPF, so members would just receive PPF compensation. And in addition, employees were likely to end up losing their jobs. The court recognized that this was a momentous decision, as it put it, for the trustees, but gave its blessing to that decision. The court said that the decision was appropriate in the particular circumstances of the case. But there may be cases where via restructuring, a better outcome can be achieved. And I'm now going to hand over to Ben to start our discussion about that.
Thanks, Richard. So first, I'm just going to talk a little bit, as Richard says, about the options that an employer will be considering when they're in distress or needing to restructure. And there are a wide range of options, so it's just going to be a bit of a whistle-stop tour through those. The first subset of those options are those steps that an employer in distress might take short of a formal restructuring or insolvency process. Financial difficulties in any particular case may be caused by a wide variety of factors, but in broad terms, employers will either be looking to manage their liquidity or deal with maturing debt that they can't afford to repay. Obviously, in those circumstances, reducing or deferring scheme contributions could of course be one very tempting way for employers to try to manage their liquidity, and that's something that may be discussed with trustees. But the companies could also look to sell valuable assets to raise funds. They'll also be looking at ways to raise new money, either through equity injections or more likely in times of kind of more acute distress on a super senior basis, which adds further secured debt to an employer's balance sheet. And that debt in a stressed or in a distressed scenario is also likely to be relatively expensive, taking a potentially larger portion of a company's cash flow and most likely imposing strict terms in terms of the use of the employer's assets and its otherwise free cash. Now, all of those things are likely to have significant impacts on the employer's covenant, and trustees should regularly refresh their advice and their analysis, stay in regular communication with employees in these circumstances, so that they have the information to step in where needed, particularly where insolvency is a possibility. But it also isn't necessarily the case that any of that is inherently a negative outcome for pension schemes, because clearly an employer continuing to trade, even if it's making reduced contributions, may be a better outcome than an insolvency, otherwise caused in part by those high contributions. But it does require trustees to consider the scheme's position very carefully, particularly where the scheme is being asked for consents or concessions. And trustees should consider the range of options for mitigation of the impact of that kind of activity. We'll talk a bit later about contingency planning, but trustees should consider the range of mitigation options available to them, including taking security, additional credit support from other companies in the group, and other contractual protections such as negative pledges. Moving on to the restructuring processes available for employers short of formal insolvency. The big change in the restructuring market in recent years, which we expect to be a significant source of activity over the next 12 months, is the restructuring plan process. And you may have heard or read about this since it was introduced in 2020, but it is a major new restructuring tool that is being used frequently in the market and driving new behaviours. I won't get into the detail of the process itself, but in short, it's a quasi-insolvency process modelled on the existing scheme of arrangement process in the UK. And I say quasi-insolvency because it's in the Companies Act rather than the Insolvency Act. And as Richard said, it isn't a qualifying insolvency event for the purposes of triggering PPF assessment or the Section 75 liability. However, the process is only available for companies in financial difficulties. And that's important because the context of distress and those financial difficulties gives the policy backdrop to the significant new power that's included in the process, which is that the court can sanction a restructuring plan that has only been approved by senior creditors, even if the proposal itself compromises junior and unsecured creditors, including write-offs. That wasn't possible under the old regime, and this is the main reason it's being more widely adopted by companies looking to restructure. Importantly, it is debtor-led, and so staying close to an employer that is looking at its restructuring options remains fundamental for trustees. Our expectation is that the development may actually be positive for trustees who can use their existing relationships with employers to make sure they're in the room when restructuring discussions are taking place. But of course, we'll see how that plays out in practice. We're expecting restructuring plans to be prevalent because they give the employers the ability to implement a comprehensive restructuring of a company's capital structure and also an operational restructuring within the same process through this ability to bind whole classes of dissenting creditors. At the same time, the process requires 2 court hearings and extensive documentation, which makes the process relatively expensive. And the fact that you're in court on 2 separate occasions gives dissenting creditors a clear and obvious platform to formally object to the process, raising the risk for employers. So a plan isn't to be pursued lightly, but we still expect it to be prevalent in the market, and it's becoming more commonly used by both large companies and we expect more mid-market size companies as well. The other options for distressed employers may be more familiar and are tried and tested in the market over a number of years. The first is a scheme of arrangement, which is a very similar process to the restructuring plan, as I mentioned, without that additional power to bind dissenting classes. So you do need the consent of all classes voting on the scheme. We don't expect that pension schemes are likely to be directly involved in schemes of arrangement for a variety of reasons, in particular the need for all classes to vote in favour. But if trustees do come across them, they should still focus on being involved in discussions at as early a stage as possible. Next slide, please. Now I'll just talk briefly about the insolvency options available to employers looking at restructuring, with the objective of rescuing their business. The first is the company voluntary arrangement, or CVA. This is a tool available to companies looking to compromise their liabilities to avoid a terminal insolvency process. It can only be used to compromise unsecured liabilities, unlike a restructuring plan or a scheme of arrangement. So it has been most popular for companies with large real estate portfolios to adjust long lease liabilities, but otherwise it's usually used as part of a wider restructuring where companies are trying to reset their balance sheet. In terms of the process itself, it requires all unsecured creditors to vote in a single class, and importantly, that includes pension liabilities, including unpaid contributions and any Section 75 liability that is triggered. Within those boundaries, the process itself is still a powerful tool, and importantly for debtors, it is company-led, again with the support of an insolvency practitioner, and it only ends up in court if challenged by a creditor, which does reduce the cost on a company. As we mentioned earlier, trustees should be vigilant because a CVA is a qualifying insolvency event which triggers a PPF assessment period and the contingent Section 75 liability. So trustees should be looking to engage with employers before a CVA is proposed to be able to help shape the proposal where necessary. And the PPF should also be engaged in those discussions for the reasons Richard mentioned. The second main option is administration. Now, this is the process where a company often ends up where it hasn't been able to achieve another form of restructuring, but here we'll just focus on the process from a rescue perspective. And in that context, it often gets used in two main ways. The first is through a pre-packaged administration sale, which is a sale of the whole or part of the company's business, which is agreed prior to the appointment of the administrators, with the deal being completed by the administrators shortly after their appointment. The benefit of this process from a company and a lender perspective is that it allows the company to sell only the viable parts of the business and for that business to continue trading while leaving behind unwanted or worthless assets and also the debts that the company cannot afford to sustain. Where the company that is being sold is the employer itself, the ultimate risk for a pension scheme in that is a Section 75 liability being left behind as an unsecured liability in the old employer. So trustees should engage early to understand the scheme's position and the decision-making process being undertaken by the employer, particularly where the sale is either to the employer's existing lenders or to a connected party. However, companies, lenders and buyers in these circumstances will be very wary of the consequences of the regulator's enforcement powers, which we'll come on to talk about. Where other group companies are the subject to the pre-pack, trustees will still need to be aware of the impact of the new financing arrangements in the new group, particularly where the lender's security package is being changed and assets are otherwise being moved around, which will obviously affect the covenant. The main alternative to that is a trading administration with a view to the administrators continuing to trade for a period while attempting to either find a buyer for all or part of the business, raise new money, or otherwise just buy time and breathing room to find an alternative solution. Again, trustees should engage early to understand the implications of the strategy and the impact on the scheme if this is where the situation is likely to end up. The last point on that slide is liquidation, which I won't spend too long on because that's the process that gets used when there's really no prospect of rescuing the business. However, trustees, as Richard mentioned, should be aware that unpaid contributions, as in the Bywater case, can be used as a tool to exert pressure and ultimately to wind up an employer in due course. There is a final option which is only available to employers of pension schemes, which is the use of a regulated apportionment agreement, which I'll touch on in more detail in the second case study, but it's fair to say at this stage it's not commonly seen or used and does require detailed consideration by the scheme, the regulator and the PPF at the appropriate time. Next slide, please. So having talked about the options available for distressed employers, I'm now just going to look at two case studies that the Mayor Brown team have been involved in, where pension schemes have been involved in different types of restructurings with a view to aiding the rescue of the company while also achieving better results for members than if an insolvency had occurred. The first one on the screen is Retail Co. This was a retailer in financial difficulties. It was in financial difficulties pre-pandemic. But it had substantial secured and capital markets debt, and it had a substantial deficit for its DB scheme on a buyout basis. The lenders put together a restructuring package, which involved a pre-pack sale of the employer's holding company, new money going in on a super senior basis, and a CVA of the employer to reset their lease portfolio. Now, as we've mentioned, the proposal of the CVA would obviously be a qualifying insolvency event triggering PPF assessment and the contingent Section 75 liability. those things in this context gave the scheme the ability to vote down the CVA, or at least the PPF, who would otherwise step into the shoes of the trustees as creditor, and the size of the deficit also gave them the ability to do that. So this gave the scheme and the PPF some leverage in negotiations in the restructuring with the lenders. The result was a deal whereby the scheme would continue to receive substantial contributions in the near term towards reducing the deficit, and the scheme would then also participate in the security granted to the employer's lenders on a junior basis to the new money to give them some downside protection. But that's an example of a restructuring resulting in a deal rescuing the business as a going concern, but also achieving a better result, a better outcome for the schemes than might have been the case if the employer had gone into an insolvency process. Although, without spoiling the happy ending, the company did ultimately end up in insolvency during the pandemic in any case. Next slide, please. This second case study is just an example of the use of the regulated apportionment agreement that I described earlier, which was used to rescue a business and achieve better outcome for the scheme than the otherwise inevitable insolvency through effectively a divorce of the scheme from its employer. Here, Hoover the Hoover scheme had a substantial deficit, and it had failed in previous discussions with the pensions regulator and the PPF around early restructuring possibilities. The situation continued to deteriorate from there to the extent that the company couldn't any longer afford to meet its DRC obligations without support from the shareholders, which it was clear at that point wasn't forthcoming. In this situation, the regulator appointed a skilled person under the Companies Act, the Pensions Act, to assist with understanding the balance sheet and the level of DRCs that the company properly could support. But this just confirmed for the regulator that the company's financial position was deteriorating rapidly, and it really couldn't afford any reasonable level of DRCs without further funding. Other financial advice taken in conjunction with that advice made it clear that an insolvency was inevitable in short order without action by the pension scheme. The company made a further proposal for an RIA, which was negotiated and ultimately agreed with the regulator and the PPF, involving the scheme liabilities being apportioned to a new co, which would be wound up shortly thereafter, so that the scheme would enter the PPF. But there was also a cash payment of around 60 million, and payment of the scheme's costs and expenses in relation to the arrangement, and also a 33% equity stake for the PPF in the original employer as an anti-embarrassment measure. And those points are in accordance with the guidance for restructurings that the PPF has published. So, having been satisfied that insolvency was the only alternative to this deal, the view was that this was a better outcome because it involved cash coming into the scheme that was in an amount that was better than the estimated outcome statement on an insolvency, and the deal was fair when you compared it to the compromises being made with the other creditors, including the write-off of shareholder debt. So those are just two examples, of scenarios where the schemes have been able to achieve better outcomes through a restructuring, working with distressed employers than an insolvency, and also allowing the business to continue as a going concern. And with that, I'm just going to hand over to Henry.
Actually, it's
Richard
again for the next couple of slides. Thanks, Ben. So the past few years have seen the emergence of new options, new vehicles for trustees who cannot afford to buy out benefits. And the headline grabber here have been the super funds. So a super fund is essentially an occupational pension scheme which is designed to operate as a consolidator. The idea is that trustees transfer all assets and liabilities to the super fund, and that the employer is then released from liability. So the employer covenant under the transferring scheme is effectively replaced by access to a capital buffer which the receiving scheme has, and that capital is put up by the super fund provider and perhaps also by the employer. Two key players have emerged, Clara and the pension super fund. Clara, as people will know, has recently announced its first completed transaction with the Sears Retail Pension Scheme So just to focus on Clara, that's a segregated arrangement, meaning that if it transacts with, say, the Greenco pension scheme, then Greenco assets and liabilities go into a separate ring-fenced section within Clara. And Clara will then seek over a period of years to reach a point at which the Greenco liabilities can be bought out. The provider shares in any gains only if and when that buyout is achieved. The PSF model is somewhat different, as outlined there on the slide. Super funds can, in principle, offer a win-win for trustees. They may improve member security while also enabling an employer to be released from liability. But we have to acknowledge they're not as secure as buyout. And in addition, the target market may be fairly small. The strongest pension schemes are still going to be working towards buyout, while the weakest schemes won't be attractive to the super fund providers. Besides super funds, we've seen the growth of capital-backed funding arrangements and journey plans. Essentially, these are investment products which target an agreed return over an agreed period, for example, gilts plus 0.5% over 5 years. The provider puts up capital which underwrites the target return, and any returns achieved in excess of the target will go back to the provider. So that's how they would make their turn potentially. Typically, the employer remains on the hook, so that's an easier call for trustees than super fund arrangement. But of course, the employer will benefit indirectly to the extent that the arrangement either improves returns or reduces volatility. We've seen about a dozen providers enter the market with many different models out there. Some models include extra elements to provide flexibility in the event of employer insolvency. These new arrangements could be attractive for trustees if they facilitate the journey towards buyout, but trustees will need to look carefully at the adequacy of the capital which underwrites the target return. And trustees will also need to understand the extent to which they'll be locked in for the duration of the arrangement. So where does the regulator stand on all this? Well, that's a talk in its own right, but just to pick out a few points. As alluded to by Ben, legislation has extended the regulator's powers to intervene where corporate actions have disadvantaged pension scheme trustees. The regulator now has power to impose a contribution notice on employers and connected parties where their actions have materially weakened the employer's ability to support a DB scheme. In addition, as we all know, there are new criminal and civil penalties for anyone who engages in conduct which risks accrued pension benefits. It's early days, but employers and others involved in restructuring will need to tread carefully to ensure that trustees don't find themselves unduly prejudiced. As to super funds, the regulator has instituted its own regime ahead of any statutory framework. Clearance, the regulator says, should be sought for any transaction which involves a super fund. And for that purpose, the super fund will need to meet various criteria set out in the regulator's guidance. Furthermore, the transferring trustees will need to ensure that the regulator's specified gateway tests are met. Broadly speaking, those tests are going to be met only if buyout is not achievable for the transferring scheme, and if the transfer is expected to improve member outcomes relative to the status quo. As to capital-backed arrangements, the regulator has recently announced that it will be publishing guidance next year. In the meantime, trustees are told to liaise with the regulator well in advance of any proposed transaction. Henry's now going to take over to talk about a few practical points for trustees in particular.
Thanks, Richard. And yeah, as Richard says, I'm going to talk about contingency planning and some steps that trustees and in some circumstances employers can take to ensure they're in a good position to react should they find themselves in distress scenarios or needing to react to restructuring proposals. So just starting with some general points about the planning process. This is very much contingency planning that can be done now as part of business as usual. and schemes shouldn't wait till they're in a distress scenario to start making these plans, because once you're in that scenario, timeframe is going to be reduced and there's going to be different pressures on some of the key stakeholders, making decision-making harder. So being prepared now should allow schemes to react quickly and efficiently when needed. And also just more generally, a lot of these points, as you'll see, are sort of more general points that, although have specific application to distress scenarios and restructurings, they go to the general good governance of a scheme. So there's a benefit to this planning more generally rather than just in these specific scenarios. The pensions regulator has specific guidance on this topic, which is called protecting schemes from sponsoring employer distress. And in that guidance, it distinguishes between sort of best practice planning for sort of stable employers with stable covenant, but also then it sort of distinguishes then between employers that are showing signs of financial distress and employers that are facing the prospect of insolvency. And for each different category, it provides that slightly different approaches should be taken, but it expects schemes in all of those categories to be taking some steps to plan, in the way we're going to talk about. And also much of that guidance refers back to the wider guidance from the regulator, which shows its broader application. Next point there is going to be sort of trustee-led planning, but it very much should be in conjunction with the sponsor where possible, because there are going to be benefits to both for taking part in this planning exercise. Trustees and employers should be aligned on wanting the best outcome for both scheme and its members, and also the employer and its employees. So there's benefits to both to being involved in the process, and there being a joined up approach will allow trustees and employers to be aligned, and each can have a good understanding of what might be asked of them in different scenarios. And similarly, trustees are going to be reliant on advice from professional advisors in these scenarios. So having your advisors lined up and ideally involved in the planning process should be beneficial to the scheme. Obvious advisors who are likely to be needed will be covenant advisors, actuarial advisors, and legal advisors. And also, as part of thinking about your advisors, think about whether they've got the right level of expertise and experience and breadth of knowledge to help you in your particular scenario, and particularly whether that expertise and skill is sort of matched with the teams who will be acting for effectively the other side, the finance parties or the company. Because even in consensual restructurings, you can expect tough negotiations. So it's important to make sure that your advisors have the appropriate breadth compared with the parties who will be acting for the other side. If we just go on to the next slide, we'll look at some areas where trustees will need to have a good understanding as part of their contingency planning. And as alluded to earlier, a lot of these are very broad points that will be general to the day-to-day running of the scheme, but they have a particular focus in a restructuring or distress scenario. The first one there on the left-hand side, we've got understanding your scheme, and then the first one being understanding the balance of powers between your trustee and your sponsor. There's various powers which are likely to be relevant in the scenarios we're talking about. So obvious ones would be substitution of principal employers or change of employers more generally. What events could trigger the winding up of the scheme, or who has contribution powers under the scheme. And understanding all those key powers will help trustees and employers understand where the control lies, what leverage parties might have over one another, and what other consequences there might be from certain actions. An obvious one being, does an employer ceasing to participate in the scheme trigger the winding up of the scheme? So a good understanding of these will help understand the balance between the parties. The next point in relation to the scheme is understanding the scheme's statutory employers. The scheme's statutory employers are those that are legally responsible for the scheme and would be liable for the Section 75 debt if triggered. Obviously, you're going to need to understand your statutory employers to fully understand the covenant that stands behind the scheme, but also what corporate activity is relevant to the scheme, and also, as was mentioned earlier, the statutory employer's insolvency event will be the event that could trigger the PPF assessment period. So there's various reasons why it's important to understand the statutory employers. And that may require sort of a tool back through history, it's not always immediately obvious who the statutory employers are. So it's definitely something that can be benefited from being doing well ahead of being in a distress scenario. In the middle there, we have understand your sponsor, and the first point being understand your employer covenant. Understanding your covenant is obviously going to be vital to understanding the financial support available to your scheme, and that's going to be the case as part of your regular valuations or in relation to specific transactions. But the regulator expects schemes to carry out proportionate covenant reviews on an ongoing basis, so between valuations, and that will form part of the scheme's wider integrated risk management framework. And carrying out those regular reviews will allow trustees to monitor developments and be alive to changes or risks that materialise at an early stage, so that they can take action if necessary to strengthen the scheme's position when there's early signs of risks materialising, rather than once you're in the distress scenario. What I said that trustees should carry out proportionate reviews of covenant, and what's going to be proportionate will obviously depend on a scheme's specific circumstances and risk profile. But the regulator's guidance provides that trustees should be prepared to engage with management regularly, challenge financial forecasts and stress test assumptions as part of that monitoring. And then if an employer suffers covenant deterioration or is showing signs of distress, that monitoring and those reviews should increase in frequency and intensity. And also, schemes should understand the potential returns to the scheme in the event of insolvency. So there's clearly quite a lot that's expected there in terms of covenant reviews, and we think that that approach is consistent with upcoming changes to the scheme funding regime, where covenant's going to have a greater prominence, and it seems like the regulator will expect trustees and advisors to take a fairly granular approach to covenant assessment. In the right-hand column there, we've got understanding your legal requirements. These are sort of much broader topics than we're covering today. So some of them Richard has touched on earlier, but they're there really just to note certain areas where trustees should have a good understanding, which is going to be part of their business as usual, but also specifically in these scenarios. Trustees should think about whether they have sufficient knowledge in these areas, or whether there's areas where further training or expertise is required. Just some examples of, as a trustee board, do you understand what notifiable events would require you to make notifications to the regulator? And do you know what circumstances trustees should be seeking mitigation as part of a transaction or restructuring? So they're things to have in mind, but which are sort of beyond the content of today. If we just go on to the next slide. And so with an understanding of the scheme, your employer, and the legal requirements, these are some more sort of specific processes and structures that can be put in place as part of the contingency planning. As mentioned, this planning is all going to form part of the scheme's integrated risk management framework, under which trustees are required to assess, manage and monitor funding, investment and covenant risks of the scheme, and how those different risks interact. The framework should be documented, so it's clear what particular risks have been identified for your scheme and what decisions have been taken. And as part of that, trustees should have contingency plans for specific risks that are identified for your schemes. And ideally, those contingency plans should be as specific as possible. So identifying what trigger events will require certain actions by the trustees, include specific actions, specific responsibilities, and consider whether it's appropriate to delegate certain responses or actions to individuals or subcommittees in certain specific scenarios, so that meetings can be convened and decisions taken in short timeframes. And just a couple of examples of things that are given. The PPF and its contingency planning guidance gives us examples of things which trustees should think about. Sort of practical things, sort of think about your payroll and your banking, and has it been considered whether they can still function if a sponsor suffers an insolvency event? And similarly with documentation, sort of has it been thought about where all historic scheme documentation is stored? Is it easily accessible in the event of an insolvency? Is it maybe necessary to look back over historic documentation as part of a transaction or as part of a PPF assessment period? So they're all things that can be thought about well in advance of the distress scenario. The next point we got on there is information sharing. So trustees are obviously going to need information from their sponsor in order to understand the scheme's covenant. So trustees should think about putting in place information sharing agreements, which clearly set out legal obligations on the employer to provide the information that's going to be needed to perform proper covenant reviews. I think even where there are good relationships currently mean that sort of formal agreements aren't needed, circumstances or personnel may change, or different pressures in different scenarios. So having a documented legal agreement in place is likely to be helpful. Got governance on there, which is obviously very broad and sort of obviously clear records, clear policies and processes in general is going to be helpful for the day-to-day management of the scheme and particularly in distress scenarios. I think one to draw out there is just conflict management is likely to be important in distress scenarios. And trustees should have a clear policy on conflict management, which should set out exactly how the trustees are going to manage conflicts in general, but also any specific conflicts that are known to likely to arise due to the personnel involved. And it can go as far as considering when resignation in certain trustees may be required because of the conflicts are too sensitive, or circumstances where the appointment of an independent trustee may be the best option for the scheme. Just one of the points on that, just trustee knowledge and experience. I sort of alluded to it earlier in terms of understanding your legal requirements. But more generally, as part of your governance, you should obviously be reviewing whether your trustee knowledge and experience is appropriate for your scheme circumstances, and think about whether there are any particular circumstances that mean specialist knowledge is required, and whether that can be addressed by training or whether a professional trustee may be needed. The next point on there is member communications. So member communications are likely to only be needed sort of, I guess, relatively late in a distress scenario, but it's important that trustees can have a plan in place as to how they're going to deal with member communications in advance, at least at a high level, an idea of who will be responsible for communications, and what the trigger events might be for communicating with members. Obviously, if there is wider knowledge of distress scenarios, members are likely to be concerned. So being in a position to react promptly is going to be beneficial to members and should hopefully sort of preempt member queries. And the regulator's guidance also notes that members in a distress scenario are at risk of scams. So it's something that trustees should be mindful in their communications with members, is that members may be more vulnerable in distress scenarios. And there's a final point on that side, which again is sort of a much more general point, but is your scheme buyout ready? Even if a scheme is not looking to transact with an insurer or another provider at this time, circumstances may change, and that may become the best or only option for the scheme, depending on developments. So think about whether there are steps that can be taken now to be prepared so that you're in a good position to approach an insurer and get the best outcome for the scheme. And a couple of obvious ones that can be sort of done well in advance and will benefit the scheme more generally would be, is the scheme's data in good order, in a position that would be well received by an insurer? And another one is what protection is in place for the trustees. It's obviously going to be a priority for the trustees, but it avoids that need for negotiation at the distress point. If it's agreed well in advance, what protections will be put in place for trustees in the event that the scheme is transacting with an insurer and ultimately winding up. So that's pretty much everything I want to cover. I think just as a final comment, I think the regulator's guidance all notes that the planning the trustees should be doing needs to be proportionate to your scheme. There's obviously going to be costs involved in that planning, but there's clear benefits to doing that planning, but you should be planning in a proportionate way that's relevant to the risks that have been identified to your scheme, not planning for sort of risks that are likely to never affect your scheme. It should all be relevant to the risks you've identified to your scheme. I'll hand back to Richard.
Thanks, Henry. So we started with the Blueco example where insolvency was terminal both for the employer and the scheme. and members' benefits ended up being scaled down. And we've looked at how restructuring may enable a better outcome, the survival of the employer, the scheme, or possibly both. Trustees will have a key role to play in any restructuring, and we'd see recent developments here as positives for trustees, stronger regulator powers, and new vehicles which may help with the journey to buyout, or indeed offer an alternative destination. Nevertheless, trustees may find that they have to make, to go back to the Bywater case, momentous decisions, and to make those decisions quickly. So to pick up on Henry's point, some contingency planning now may help trustees achieve the best outcome for their members in the event that the worst happens. Having made those pensions focus points, Ben, was there anything you wanted to add by way of wrap up from an insolvency and restructuring perspective?
Yeah, thanks, Richard. I think it's fair to say that, you know, while there are a number of ways that any distressed scenario can go, generally once a formal insolvency or restructuring process is underway, where, you know, creditors are fighting for a share of a kind of a diminishing pie, the outcome inevitably becomes kind of less predictable and potentially worse for pension schemes. You know, typically in the past, key financial creditors to companies would work up proposals and then put them to schemes as almost as a fait accompli with the with the sponsor or the employer. So, but, you know, as we talked about, the new debtor-led restructuring process, which is likely to become more common, together with those, you know, new enforcement powers, means that you know, trustees and employers can instead focus on working together on consensual proposals, or, you know, proposals that benefit the scheme, that can then be put to financial creditors first. You know, particularly bear in mind all of those exit options that Richard talked through. I think the key is still, and will always be, getting into the situation at the earliest stage possible, before the distress can really begins to bite. I think the only other thing to say is that there's also substantial changes to the way that companies that operate cross-border can be restructured. I'm going to use the B word, Brexit, as a significant part of how those change, you know, how that changes the environment. And, you know, the introduction of new restructuring tools around Europe and in Asia and also offshore means that companies that do trade and operate cross-border have lots of options that may not have been available to them in the past. We've been through the UK options, but also understanding the international elements of any situation is also fundamental, and you know, rigorous contingency planning is a key part of that.
Thanks, Ben. So that covers everything we were going to say. I'm just checking the chat for any questions. We've got one which feels like a question for you, Ben. How do we think other stakeholders, lenders, etc., now view pension schemes and the regulator? Are the new regulators' powers seen as a game changer? I assume that lenders, etc., will be aware of them, but how material are those powers felt to be?
I think it's fair to say that they shouldn't be described as a game changer, but certainly it's an important, you know, they're an important factor when lenders are looking at these situations. I think, you know, lenders have different risk appetites in different situations. At the same time, we have seen on a number of transactions, particularly with high street bank lenders, that it is important in their thinking, and so they are having an impact on the way these situations are progressing and the outcomes. I think, you know, between this and the new debtor-led process, I think between them, those are having substantial impacts on the way lenders are behaving.
And one other question, which I'll pass to you, Henry, if that's okay, as it relates to contingency planning. The regulator's guidance distinguishes between stable employers, distressed employers, and employers facing insolvency. Does the regulator define or explain those concepts? How do trustees allocate their employer to one of those different pots?
Yeah, so the regulator doesn't define those categories precisely at all. It sort of explains it's very much going to be a judgment of the trustees depending on your employer's specific circumstances. It gives some sort of broad guidance and some indicators of what things it would consider warning signs of distress, so which would move the employer into sort of the distressed category. But they're pretty broad indicators, things like cash flow constraints or loss of key client contracts. So it's going to be very much a judgment based on your employer's specific circumstances. And in terms of sort of the employer facing insolvency, a bit similarly, it's sort of not specific, but it refers to employers in that category being employers where insolvency is likely. And then when you're in that scenario, it expects trustees to be taking specialist advice from restructuring advisors. So I think to be in that category of facing insolvency, it's very much sort of it's pretty far along the distress curve. Whereas the employers facing distress or with prospects of distress is definitely much more of a judgment for trustees.
Thanks, Henry. And I'm not seeing any other questions, so let's draw the webinar to a close. Should say thank you to everyone who's joined today. And if you do have any questions or comments, please feed them through to one of us. So with that, I'll say goodbye and wish everyone a very happy Christmas.